Thank you very much, Donald. I perhaps will not claim Dave's total disinterestedness in the outcome of these issues. I am somebody who, first of all, have serious concerns about disincentives to innovation if we apply antitrust laws and other laws too broadly to limit the patent laws. And obviously, from our previous speakers, it's clear that the Supreme Court decision in activists, or FTC versus activists, largely determines how broadly antitrust law is to be allowed to interfere with patent rights. And I think that Adam is absolutely correct that the FTC didn't really win the activist case, and although it is sometimes being portrayed that way, and there have been a fair number of decisions that have come out since then that have tried to expand the court's decision. But let me just briefly describe the activist decision as I see it. First of all, it was a very close decision. There were five justices in the majority, and two of those justices, Justices Ginsburg and Kennedy, are no longer on the court. So I think there's a very strong possibility that if this issue were to return to the court, that the present Supreme Court would perhaps have a less broad view of the antitrust implications that are at issue here. But in any event, the activist decision didn't simply say we reject the FTC's position that a quick look analysis was warranted, and that these sorts of reverse payment settlements are presumptively invalid. And instead, as previous speakers have mentioned, the Supreme Court adopted a rule of reason test. But more importantly, the court said it is not always true that antitrust analysis applies, that it only applies when the sorts of payments that are made from a patent holder to an alleged infringer are large and unusual, that antitrust law is implicated at all. Now, very clearly, large cash payments, which were at issue in activists, are covered by the decision. But as Dave mentioned, there is serious question that anything other than cash or cash equivalent, like gold bullion, would be covered. And so that's an issue that is still being litigated in the lower courts and may well get back to the Supreme Court relatively soon. I should say that I've spent a lot of my career litigating pharmaceutical-related issues. I have been involved both in activists and a number of other Court of Appeals cases on this issue of antitrust liability for patent settlements, but only as an amicus curiae. I have not ever represented a party in one of these cases. But as I mentioned, some of those cases, post-activists that we've been involved with, have gone so far as to say that basically any transfer of value from the patentee to the alleged infringer implicates antitrust law. But there is a case going on right now in the Fifth Circuit that I think stands a relatively good chance of changing that. The case involves a small generic company by the name of Impax that is fighting an FTC order claiming that Impax violated antitrust laws when it entered into a patent settlement with a brand name company by the name of Endo Pharmaceuticals. The Endo, it paid no cash to Impax, but among other things, it provided Impax with what Dave referred to as a no AG agreement. The that during the 180 days of Impact's right to exclusively market a generic version of Endo's drug, that Endo would not compete by marketing its own authorized generic version of the drug, which a brand name company would otherwise be allowed to do. In the Impact's case, this is a case that was not originally brought in court. Rather, the FTC filed an administrative proceeding against Impacts and also against Endo, which very quickly settled, which in fact most companies have been doing in recent times. So the agreement was entered into before the 2013 activist decision, and in the years since then, there really have been very few reverse payment settlements. Most of the litigation that's been going on have involved patent settlements that preceded 2013, and most of the major drug companies have settled the antitrust cases brought against them rather than to continue to fight. But in the Impact's case, Impacts did defend against the FTC, and the matter came before an administrative law judge, an ALJ, and the ALJ actually ruled in favor of Impacts. First of all, it said that there really was no evidence that even if there had not been this agreement under which Impacts agreed not to compete for about 3 years, there's no evidence that a generic product would have gotten onto the market any more quickly. In particular, there was evidence that the only way they could have gotten on the market would have been if Impacts had agreed to market its drug at risk, meaning it would have had to market while the litigation between Impacts and Endo was still going on, and therefore if Impacts had lost, it essentially would have been betting the company, because the damages that you incur if you end up marketing and are later found to have violated the patent are such that it basically can bankrupt the company. So the ALJ said really no evidence that it was delayed. Moreover, more importantly, the ALJ found that there really was no real evidence that that competition was hurt at all, because on the one hand, yes, for several years entry was delayed, but on the other hand, there are lots of pro-competitive effects that arise from any settlement. I mean, merely settling litigation is pro-competitive. Moreover, the patent system itself is very pro-competitive. In the short term, it has a purpose of delaying competition, but the whole point of having a patent law is the belief of Congress that in the long term, competition will increase, because we will have more innovation if we give incentives to people to develop new products, and we give those incentives by giving them short-term monopolies for their products. Now, not surprisingly, I guess, the commission ended up overruling the ALJ, because after all, it was the commission that originally had brought the charges, and so it felt that its original opinion was correct. And what it said was that we don't care if the overall effect of the settlement agreement is anti-competitive. What we think is that you have to look at each particular component of the settlement, and if there is any component that is itself anti-competitive, then that's enough to find an antitrust violation. So it looked at the no AG agreement and said, well, clearly that is anti-competitive when considered by itself, and therefore we find a violation. And I think that sort of analysis overlooks the fact that when parties enter into a settlement, they do so based on the overall terms. And yes, of course, the no AG agreement gave a significant benefit to impacts, and one has to weigh that against the other portions of the settlement. So that's what impacts has said in its appeal to the U.S. Court of Appeals for the Fifth Circuit. That case was orally argued last June in front of a three-judge panel. Two of the three members of that panel are Republican appointees to the court, have a reputation as being more conservative on antitrust matters. Given that the oral argument was more than 7 months ago, I think we can reasonably expect that there will be a decision any day now. And based on the oral argument, there's a good chance that the Fifth Circuit will go against what some of the other courts of appeals have said about the broad interpretation of the Supreme Court's activist decision, in which case, if there is a split in the circuits, I think there's a reasonably good chance that the impacts case will be before the U.S. Supreme Court next year. And if that happens, I think that with the changed composition of the court, there's a good possibility that the Supreme Court will cut back on the activist decision. Chief Justice John Roberts had written a very strong dissent in activist, suggesting that the antitrust law really should have no application to settlements that are within the terms of the patent as initially issued. Now, I understand that there are some patents that are somewhat frivolous, and that certainly can be an exception. And I think we'll be hearing from Melissa that some of the secondary patents that are obtained by drug companies are particularly weak. But I think that Congress has done a good job by creating what they call the PTAB, which allows for review of frivolous patents so that they can be gotten rid of. But in the meantime, I don't think it's appropriate to be addressing this issue through the antitrust laws. So I'll conclude there. Thanks very much.
Thank you very much, Richard. A lot of interesting things to think about so far, and we're just going to add even more. So let's move to Melissa Washington, who will give us some more to think about secondary patents. Melissa.
So thank you. So I'm going to talk about secondary pharmaceutical patents today. And there's been a lot of controversy associated with secondary pharmaceutical patents. And in part, Richard set me up very well, right? There's a lot of concern about the quality of these patents and how much these patents may be subject to these reverse settlements, where if they're low quality patents should have never been issued in the first place, maybe there's more concerns with these reverse settlements. So I think everybody here knows, right, that pharmaceuticals are an area where we think patents work relatively well. Huge upfront costs, and drug development is very risky. And once a brand name is marketed, it's cheap and fast for generics to imitate. So it's unsurprising drug companies routinely report patents are a key tool in promoting innovation in the biopharmaceutical area. Now, pharmaceutical companies typically obtain a series of patents associated with a single approved drug. Often, but not always, the first patent they obtain will be a patent on the active ingredient that forms the basis of the drug. And then later on in the phases of drug development, pharmaceutical companies may file patents on peripheral features of the drug product. So these could be a formulation patent. This would be an active and a non-active ingredient that may do with the mode of administration, such as controlled release. Could be a method of use patent, may also be something called a polymorph. So if the active ingredient exists in a solid state and a crystalline structure, which just has short range ordering, it may have different crystalline states, which refers to polymorphs. And these are important because the polymorph affects the ease of manufacture as well as the biologic activity of the drug. Now, because secondary patents are often filed after the active ingredient patent, and because patents expire 20 years from filing, often these secondary patents expire after the active ingredients. And critics of secondary patents tend to argue that these are of questionable legal validity, offering only trivial modifications over the active ingredient patent. And if these patents are really invalid, right, and shouldn't have been issued, then they do act to delay generic entry into the marketplace, kind of keeping drug prices arbitrarily high. Where defenders of secondary patents argue really there's nothing inherently dubious about these secondary patents, which are subject to the same patentability standards as other patents. And they argue that these patents stem from continuous research and development and offer some important clinical and therapeutic benefits over the patents on the active ingredient. So what I want to do with the rest of my time is present some of my original research with Michael Frakes, who's a professor at Duke, where we sort of explore this idea of secondary patents to say, look, we think some of these are really innovative and arguably justify an extension and exclusionary period, but there seems to be some others that look like they should have been never issued by the PTO, likely invalid, and didn't offer or offered very little innovative benefit over the patent on the active ingredient. So how we approached this question was looking at if we gave patent examiners some more time to review patent applications, would giving them more time result in them issuing higher quality secondary patents? And so this is what I just briefly want to kind of walk through some of our results and then kind of tie it in to the panel at the end. So in patent examination, you've got about 500,000 applications filed each year. They come into the PTO, they get routed to an art unit, which is a group of about 20 to 30 examiners that review applications in the same technological field. Once it arrives in an art unit, it gets randomly assigned to an examiner there. Patent applications, when they're filed, are presumed valid. So if examiners aren't given enough time to kind of do a search of the prior art and write up a rejection, they may end up allowing a patent that if they had been given more time, they would have rejected. And on average, examiners only spend 19 hours reviewing an application, reading it, searching the prior art, etc. Lots of anecdotal evidence, at least if you talk to examiners, that they suggest they're not giving enough time. So what we really wanted, let me just skip this, to test is if we give examiners more time, would they issue higher quality secondary pharmaceutical patents? And so to study this, what we really needed to do is get some variation in time, right? We want to look at examiners, if we give you more time, do you issue higher quality patents? And we got this variation in time in two different ways. One is if, as a patent examiner, as you get promoted up the GS scale, each promotion you get is associated with about a 10 to 15% reduction in the amount of time you're given to review applications. And secondly, we exploit the fact that in 2010, the Patent Office gave all examiners an extra 2 hours to review all applications. And then secondly, right, if we want to look at whether patent applications, if they're given more time, are they the ones being issued of higher quality? We need some sort of quality metric. So what we did was look at twin applications that were filed in the US and filed in Europe. And what we ask is patents that are issued in the US and end up getting listed in the Orange Book, right? We look to see if they were also allowed in Europe. If they were, we take this as an indication that it's likely valid. And if it wasn't, right, then this is an indication maybe that the patent is of lower quality. And so really, methodologically, what are we doing? We look at patents that are being allowed, right, these drug patents, and we see if there's differences in the likelihood of these US allowed Orange Book patents that are listed in the Orange Book, are they also allowed in Europe as a function of examiners' GS level? So remember that GS level tells you how much time they were given. And then the second approach we took is we just look at before and after when the PTO gave all examiners an extra 2 hours. Do we see a change in the likelihood of these patents also being allowed in Europe? So I just want to show you, whoops, I keep trying to change. Very quickly, just some quick results, and then I'll tie it in. So right here, what I'm showing you is the relationship between the likelihood of EPO allowance of a twin of a U.S. issued Orange Book patent and the grade level of the examiner side to the relevant U.S. patent. So I'd like you to look at panel A on the left-hand side for secondary pharmaceutical patents. And what you see is if you look on the bottom, x-axis is GS level, right? And on the y-axis is the likelihood that this US issued Oregon patent is also allowed in Europe. So as examiners get promoted up the GS scale, right, as you move along that y-axis, they get less and less time to review applications. And what happens is the applications they're allowing become less and less likely to be allowed in Europe. So what this suggests to us, right, is that the less time examiners are given, right, they're allowing lower quality patents. And then very quickly, some of our other results just looked at this reform over this 2010. What we found is if we gave all examiners an extra 2 hours, as the PTO did, then all of a sudden right after this extension where they got extra 2 hours, the applications that the examiners were allowing, these drug patents that they were allowing, there became a big jump that they also became allowed in Europe. So both of these are kind of consistent with this idea that if you give examiners more time, right, they may be allowing higher quality, more likely to be valid patents. And in the paper, we also address this idea that, look, obviously, if you're going to spend some more resources at the PTO, right, to have examiners spend more time, we only want to do that if we think the benefits outweigh those particular costs. We think this is an area where it clearly would. If we can take out some invalid patents early on, never allow these to be issued, then there may not be as much litigation ex post, right? You may not even need to challenge as many of these patents, right, if the patents that are being allowed by the PTO are higher quality to begin with. So finally, I just want to sort of wrap up. We think, that thinking about the patent office more and these particular arguments, right? How could we ensure that the quality of patents that we're issuing are high quality is sort of an important, I think, part that sometimes is lost in these sort of broader discussions with pharmaceuticals. And Adam mentioned a little bit, right, about how important pricing is right now. There's been lots of bills that have been introduced, right, trying to bring down prescription drug prices. And one of the things we thought about with our approach is simply that we think our approach of just allowing higher quality patents, allowing those patents that meet the patentability standards to begin with, right, help to preserve innovation incentives in pharmaceuticals, and some other approaches simply just like price controls, which are really blunt, right? At least with our approach, the patents that we're losing, right, are ones that didn't meet the patentability standards, that weren't new, for example, and thus we perhaps didn't even need that patent to begin with to get that innovation. And we also just note this, we think, is really low-hanging fruit. This is an easy thing that Congress could do immediately. So I just also wanted to bring in this kind of idea that patent quality, I think, is an important aspect in these reverse payments. And I know that, at least some people are concerned with this idea that you may be able to settle on this patent that's invalid, right, that should have never been allowed in the first place. So that's all I have.
Thank you, Melissa, and thank you to all of our panelists. This panel was designed to explore a wide range and a survey of the intersection between intellectual property, patents, antitrust, and other issues, including where the states are seeking to intervene to change some of the agreements that can be made. And I think we've accomplished that task pretty well. We've given our audience a lot to chew on, but I think that we've also given each of the panelists some things to think about. And I want to turn it over to the panel as a whole right now to each offer any responses you might have to something you heard, or supplemental information that you think our audience should hear as a result of the overall presentations. Feel free to jump in at any point. Dave, you're muted, but I think we'll go to you first.
Thank you. I'm sorry. I have a question for Richard out of sheer curiosity. Are there any circumstances under which you believe a reverse settlement would need to run the gauntlet through the full rule of reason? Or do you believe that in all cases they should be held immune from antitrust?
No, well, first of all, to the extent that the patent was in some way fraudulently issued, I think would call into question the entire process. And I think there are at least some cases where a good case can be made that there was really no good faith belief that the patent ever should have been issued in the first place. In terms of reverse payment, certainly if the result is that the generic drug company agrees to refrain from competition where he would not have been prohibited from taking those actions under the terms of the patent, then I think that would certainly be a valid antitrust concern. But so long as you stay within the terms of the patent, then I see no problem whatsoever. I mean, there's certainly no disincentive for generic companies to keep bringing suit after suit. If one company settles and the patent is particularly weak, the next generic company to come along will also sue, so that you really can't buy off challenges to your patents if it is so weak that generic companies really think they have a good chance of winning. I think the opposite is true. Most of these suits get brought not because the generic company thinks that the patent is particularly weak. Rather, they think that there's money to be made from filing a suit because there's no downside to these kinds of suits and a lot of upside.
I want to let Dave react to your comment, but one quick question, Richard, is how does a court test the good faith belief and the quality without some kind of more rigorous review like Melissa is suggesting? Is that really something within the competence of the court to do? And if so, what metrics would they use?
Well, you raise an interesting point, but the fact is that courts have been doing this all along. There have always been cases where courts have been willing to rule that a patent was fraudulently issued. The standards for demonstrating that are quite high, so it doesn't happen very often.
Dave, any responses to that?
I lost my train of thought. It was such another good question, but I guess, Richard, I've often thought that the generic is really argued to be sitting in the consumer interest here. They may be trying to make money. They may have a strong argument. They may have weak argument, but there's still a chance for them, and there's still a chance. I think the FTC and state enforcement said there's still a chance for consumers to reap the benefit of that risk, and so. Don't we need to assess how much value was given to the generic company in exchange for consumers allegedly having to wait for the benefits that they were received? The reason I think people argue that there should be a quick look, which I wholly agree with both of you that the court rejected, is because there's a concern that the generic is benefiting, but consumers are losing out, that you've cut out the consumer. Even if it's a weak, even if it's a strong patent, very strong, valid. I believe there were some cases where, apologies, I'm not remembering it, but where it was found that the patentee had an extremely strong case, very strong valid patent, strong case of validity, had very high percentages, and they withdrew that case. And so that was argued to be a benefit that the generic company got that excluded consumers. So how do you account for this? How do you keep the consumers in the deal, or should you just allow and should you be forcing these companies to litigate to make sure the consumers are getting what they're arguably owed?
Adam, I think you had some thoughts on both the initial question and perhaps this follow-up question too.
Yeah, I mean, this has been a great exchange between Richard and Dave, because it highlights, I think, a lot of different issues that come into play in these cases. That are also raised by Melissa's excellent presentation and fantastic research on secondary patents, which is, so there's concerns about, there are concerns, there are different doctrines that address. So was a patent, for instance, fraudulently obtained, and that's long been adjudicated under a doctrine known as and as Richard indicated, it has some really good standards for assessing whether people were making misrepresentations to the USPTO and a patent. And then, of course, there is the concerns about sham litigation and improper abuse of litigation processes, which is what ultimately led to the Noor-Pennington doctrine. And of course, sham litigation is an exception to this. And then keyed in with a lot of this also is a sense or a belief, at least within the policy debates and the narratives about pharmaceutical patents and drugs prices today, that a lot of these patents are of questionable validity. There's some, secondary patenting, which is often referred to by the pejorative label evergreening. I appreciate, Melissa, that you use that.
I did not do that.
It's a serious policy mix here of different arguments and different points being made. And I think Richard's right. I mean, we as a country have chosen to rely on the courts as mechanisms by which we usually resolve disputes between not just litigants, but more generally, it's the crucible where information is brought to bear, why we have adopted the rule of reason standard in antitrust. And to the extent that consumers are truly being harmed, or that there is harm to competition, I believe that the adoption of the requirement in antitrust that needs to be proven in order to move forward with antitrust sanctions is really important, because it's very easy at a very high general level and with kind of policy-laden word to characterize any agreement and any commercial exchange as having nefarious purposes or negative impact upon consumers, whether it's high prices allegedly or lack of access to other products and services and things of this sort. But 9 times out of 10, if these exchanges and these market agreements and these settlements are actually benefiting people and actually are benefiting the parties and are benefiting consumers and producing new products and services.
Melissa, I'm wondering if you have any thoughts on this exchange first, but and relatedly, your conclusions in many ways are about comparative institutional competency. Who should we be trusting to make quality decisions? And we see some of the flaws in any particular approach. What do you think about the exchange that's happened so far, but also about that idea of assessing the comparative value of trusting different institutions to get us to the right result?
Yeah, no, I definitely think, what my work in part, gets at is we're always going to make mistakes at the Patent and Trademark Office, right? They make 500,000 patentability decisions a year. There's no way they're going to get it right. And certainly they shouldn't spend infinite amounts of time, because not every patent is going to be commercially viable or economically important. And so there is, at the heart of it, a trade-off between how much resources do we want to put up front ex ante and how much resources do we want to put ex post to allow the courts to kind of weed out invalid patents. And I think this dovetails up in part on the reverse settlement sort of agreements. And so my sort of at least belief is that we should be spending more resources up front at the PTO to kind of screen patents that we know are going to be valuable better. We know these pharmaceutical patents are highly economically valuable. And if we make mistakes on these, a type 1 or type 2, right, it's going to be really costly to society. Either we're losing a valuable drug, right, or we're allowing a low quality patent to be issued. And so I think that's an important, and my belief is we should be thinking more upfront with respect to on the Patent and Trademark Office, spending more resources up front. I think it's interesting. I think, what Dave brought up with the consumers is always, I'm not an expert in these reverse settlements, but it's always what obviously is troubling with this to the courts, right? It's just how pharmaceuticals are priced, right? The brand name drug is priced so high and the generic brings it down to arguably close to something like marginal cost. So the brand name could pay the generic to stay off the market, where the brand name is happy and the generic is happy. And arguably, depending on how it's set up, right, you can see situations where the consumer is the loser. And then I think, it's been an interesting discussion to think about how do we determine, right, when is actually consumers losing, right, with respect to payment or lack of long-range competition. And I think that's what makes these reverse payments really kind of difficult to figure out how they should all come out, especially as they become more complicated. It's not just cash, right, but all sorts of other things that are being offered.
Can I ask you, just for the benefit of our larger audience, a lot of people are expert in things, but can you explain to people, the Law and Economics Center and much of this programming is designed to help people, get the terminology right. So can you explain to people type 1 and type 2 errors for the folks who out there who don't know that?
Yes. Yeah, so I just mean, right, if an examiner erroneously denies a patent that meets the patentability standard, right, if that's a really important drug that is needed in order for a drug company to bring that drug to market and commercialize it, that's a huge loss to society, right? If we don't get a drug that would have been really valuable because the examiner erroneously denied it, the other harm that we're talking about would be if an examiner erroneously granted a patent, right? That was invalid. And I sort of focus more on that, because that is at least the arguments that people are making with respect to secondary patents, is there's a concern that too many of them are being allowed that don't meet the patentability standards.
Thank you very much.
Would consumers still not get the drug? Would consumers still not get the drug if the patent is denied? They only get it if the patent is granted? Honest question.
So I would say my view is outside the Orphan Drug Act. So if you have a drug that is covered by something called the Orphan Drug Act, which is covered for diseases for, I think, if I'm remembering correctly, less than 250,000 people, right, that are affected. There are special incentives that are set up with respect to the PTO. So you will most likely see drugs, I think, develop there without a patent. I do think it's still rare to see drugs developed without a patent outside of the Orphan Drug Act. We have something called data exclusivities, which are these areas that kind of promote innovation at the FDA, but I think they're too short to do the work of what a patent can do.
Other reactions from the panelists?
Yeah, I just want to quickly make 2 quick points about follow-on innovation that's patented and also the marginal cost point that Melissa made. There's a tendency to think, oh, this follow-on innovation, that this is similar to other types of commercial arrangements. This is something nefarious going on, things of this sort. This is a very common practice. I mean, innovators going back to the 19th century, Thomas Edison and Alexander Graham Bell, often got additional patents on top of their original patents, their primary patents, because they created new innovation. Their patent facilitated more commercial exchanges and development of new technologies, and they got new legitimate patents on this. And if you think about pharmaceutical innovation and the drug development process, there's an incredible amount of innovation that has to go on after the discovery of the original molecule that's active against an antigen that invades a body. To get just even that molecule through the hydrochloric acid in one's stomach, and how to get it absorbed through the lining of one's intestines and into the blood, and not have the white blood cells attack it as itself an antigen, is an incredible achievement. That's all follow-on innovation that is developed by the pharmaceutical companies. This is part and parcel of why it costs on average about $2.6 billion to develop a new therapeutic treatment. So, there isn't any, as far as I'm aware, and Melissa may maybe correct me, but that there isn't any economic study or empirical study that has definitively proven and shown in any way, shape, or form that we actually have a serious quality problem with follow-on patents on follow-on innovation, or at least there's no, as far as I'm aware, there's no studies showing that we have a problem today relative to the issuance of patents on follow-on innovation in prior decades or even prior centuries, between the 19th century or today. Maybe I'm mistaken and I missed something, but.
I
also want to make a point about the market cost point too, but I just want to throw that back to Melissa real quickly.
Yeah, let me just chime in really quickly. So I don't know of any studies that have said it's work. So what I know of is studies that suggest secondary patents in general that are allowed are more likely to be invalidated if litigated to finality. And my own work with Michael has suggested there's some indicators that as a whole group, secondary patents are of lower quality than patents on active ingredients. Not drastically lower, right? So for us, I think about 76% of them are also allowed in Europe. But that's where I think that the rhetoric is coming from, the secondary patents being of lower quality than active ingredients.
Unfortunately, we're running close to time, but I know, Adam, you have another comment to make. I'm going to ask you to hold it for your and incorporate it into your closing remarks if you could. Richard, do you have any final thoughts? If everyone can take sort of 60 to 90 seconds to give their last comments, and then we'll close the panel with an expectation the conversation will continue. So, Richard.
I want to respond, I guess, in my closing remarks to what Dave's question was, which is, if you don't get a patent, will a drug be kept off the market? And I don't think that that is a serious concern. I think that if a drug company thinks that its product is at all commercially viable, it will go ahead and get FDA approval even without a patent, but merely getting approval gives you a certain amount of exclusivity for a short period of time. I think the real problem is that if you don't have a strong patent system, and if too many patents are denied, the result is that you're going to have less money put into innovation, and you're going to have fewer new drugs developed. I don't think it's an accident that most new drugs get developed here in the United States. That's because we have by far the highest prices, and we give the most incentive for people to innovate, and I would hate to see that stop.